Good afternoon, everybody. Hopefully you can all hear me all right. You're able to have linked into this Zoom meeting with your speakers. You're all muted and the video is turned off so we can focus on the seminar. My name's Laurie Steiner and I'm a certified elder law attorney with Solomon, Steiner Peck, and I want to welcome all of you to our webinar this afternoon on the Medicaid rules. So Medicaid pre-planning, crisis planning, and the law. Some housekeeping things. I am sharing a PowerPoint with you. You'll be getting a copy of the PowerPoint after we have had our webinar today, so you can remember everything, hopefully, that you learned. If you have a question along the way, I'm going to do my best to try to answer those as we go. They're near the bottom of your screen where it says mute and stop video and participants and all of that. There's a Q&A button. So if you could put your questions into that Q&A, you can just type it into me. I will be watching for that, and I will answer those questions as we go, as much as I possibly can. So, welcome to our webinar. I'm going to start up here. So we are happy that you're here listening to our firm webinar this month on the Medicaid program. It is not an easy program. I'm assuming that's why you're here and that's why we talk about it. So why is Medicaid and other ways to pay for long-term care such an important problem? Why do I have so many clients who need help? Well, here on this slide are some of the reasons for that. Some of these statistics I think are particularly scary. Between 65 and 69, you have a 1 in 2 chance of a nursing home stay. Now, some might be just a few days or a couple weeks to recover from surgery or a fall, but there is Alzheimer's and other types of dementias. That means some people are in the nursing home for a very long time. The average stay is about 2.5 years, because either you're getting better and you go home, or you're not going to get better and you're going to stay in that facility, and your life is different when you're in a facility. It's not home. If everybody could stay home, that would be fantastic, but sometimes you have to be in the nursing home, and it isn't where you want to be, so this average stay is not really all that long. The problem is the cost of one of those years that you're in the facility is $96,000 to $144,000 annually. That is in the state of Ohio. Some states are less expensive, some states are much more expensive. The Department of Medicaid here in Ohio says the average cost for 1 month is $6,905. That's probably true in some of the southwest or southeast parts of Ohio. Up in the northeastern Ohio world that I live and practice in, it's really at the higher end of the scale. We're probably talking $8,000 to even $12,000 a month. Because of these high costs, 50% of couples lose all their assets within 1 year because they don't know what they're supposed to do. They're told by the nursing home that they have to spend all of their money before Medicaid is available. They're told by a caseworker at the Medicaid department, if they call and ask questions, pretty much the same thing. So, people are facing this financial devastation because they don't really understand how it all works and what the planning tools actually are, because there are planning tools. So that's what we're going to talk about today, about how to pay for especially the nursing home. Now, if you can stay home and you need round-the-clock care, that's great, but that's even more expensive than having to stay in the nursing home. Some people can't afford to stay at home. They have to end up in the nursing home, and it's still really expensive. So how do you pay for all of that? Self-pay is the first level. Many people end up spending their entire life savings trying to pay for nursing home care, and then they're told that Medicaid can help pay once all the money's gone. And hopefully by the time we're done with this webinar, you'll have some idea of other type of planning that you can do to protect some of that hard-earned money that you worked all your life for. There's also private long-term care insurance. Very few of my clients have long-term care insurance. It's nice if you can afford it, but many people can't afford it. The cost goes up pretty much every year because the cost of living, the cost of nursing homes, all of that increases every year, so the premiums go up. They can't raise just your individual premiums, but they can raise everybody's premiums. So that's what happens every year. Also, if you try to get into a long-term care insurance policy too late, then you may be too ill, too old to be able to afford the premiums, even if you could get underwriting. A lot of times people can't even get a policy. There are some new types of hybrid long-term care insurance policies now that are tied to annuities or life insurance policies that you have to pay like a big lump sum for. So maybe $100,000 you put lump sum into one of these contracts, and it allows you to tap into that money if you do need to go to the nursing home. If you use it all up during your lifetime, there's nothing left. But if you don't use it up at all, or there's something left over, if you did use some of the money in that policy to pay for long-term care, it at least goes to a family member. But those are also, you have to have a big lump sum of money to put into it, so not everybody can do that. There's veterans benefits. If you were a veteran during wartime, there are some benefits that are tied to assets and income and your need for health care. Unfortunately, on a monthly basis, those benefits aren't all that huge, and most folks, even with their regular income from Social Security or pension and adding in a veterans benefit amount, it's still not enough to pay the nursing home. So in many cases, we can't use those kind of veterans benefits to pay for the nursing home. It is helpful, though, if you have the right situation, to get maybe just enough money every month if you're still at home to be able to afford to pay for a little extra help at home. And maybe that's all you need in order to never end up in the nursing home and having to worry about how to pay those higher costs. So we do work with some of our clients on veterans benefits. There's something called a reverse mortgage. A reverse mortgage was really popular a few years back, not so much anymore because of the high cost up front, the closing costs that you don't actually pay out of pocket, but they roll into the mortgage are pretty high. But how that works is with a normal mortgage, or if you're trying to tap into like a home equity line of credit, on a monthly basis, you have to make payments on that mortgage. So you're taking out the money and using it for long-term care costs, but you're also having to make a mortgage payment at the same time. It might only be interest, but at some point, usually 10 years, the whole principal becomes due. With a reverse mortgage, you take out a mortgage and you can get monthly checks, kind of like a pension out of your house. You can use it to pay off an existing mortgage. You can just tap into it when you need it. So you're still using the equity in your home to pay bills, but the biggest difference is you don't have to make monthly payments. The reverse mortgage just builds up the loan against your house, the mortgage against your house, and then when you pass away or you leave the house, then it has to be sold within a year, and the bank gets their money back, and if there's any equity left over in the house, you or your family get it back. A reverse mortgage can help, again, keeping you at home. I had a client who had broken a hip, suddenly realized she didn't have a whole lot of money to fall back on, and she wanted to stay at home. So once she recovered, she took out a reverse mortgage so she would have more money to be able to pay for long-term care in her home, as opposed to having to go into a nursing home. Because a reverse mortgage, if you leave the home to go to a nursing home within a year, you have to pay it off. You have to sell the house and have the loan paid off. So it's helpful in some cases, but just like veterans benefits, maybe not so much if you're actually in the nursing home. Then there's Medicare. So we're going to go a little bit about how much Medicare pays for the nursing home. It's not a whole lot, but you need to know how the rules work, because if you go into a nursing home after a hospital stay and Medicare is paying for it, they're going to try to get you off of Medicare paying for it as soon as possible. And there's some things you can do to try to continue to get a little bit more benefit. So we're going to talk about that. But the final word, Medicaid, is pretty much the last resort for many people. Most folks, if they stay in the nursing home long enough, actually do end up having to go on Medicaid, even if they did spend everything down, because it's really the only program that helps to pay that room and board cost, that really expensive cost, plus any tail end medical expenses you might have that maybe your Medicare and your supplemental or other insurance that you have doesn't pay for. So, where Medicare stops and Medicaid begins. This is a tough issue for a lot of people. So, Medicare, you probably know, is your federal health insurance if you're 65 and over. Medicare will pay some towards nursing home costs, but it will only pay if you are in the hospital for 3 days, or what they call midnights. You have to be there past midnight 3 nights in a row to have it count as a 3-day, 3 midnight stay. And you have to be admitted to the facility. If you are only in the facility for observation, which is not always easy to tell. You could be in a room, in a gown, in the bed with the nurse and the fantastic hospital food, and you might only be under observation. Observation is outpatient. Admittance is inpatient. They're paid under different parts of Medicare, and you have to have that 3 midnight admission prior to being discharged to go to the nursing home or skilled facility in order to qualify for Medicare to pay some part of that. Now, that's the normal rule. During this pandemic, they've waived that 3-day admission requirement because there's so many people that are going to hospitals with COVID, and then the hospitals can't keep them past a certain point, and they need to move them on into some type of care facility. So they're allowing Medicare to pay some of that even without the 3 midnight stay, but that's going to go away, I hope. We can only hope. And it's going to be back to that 3 midnight admission to the hospital in order to get the coverage by Medicare, which will pay for 20 days in full and up to an additional 80 days for a total of 100 days. But days 21 to 100, you have to have a copay that you pay, or if you have supplemental health insurance or a Medicare Advantage plan, that's paid by that supplemental coverage. So you can get up to 100 days paid in full. You have to be in a Medicare licensed nursing home, and most of them are. You have to need skilled care like rehab of different types, or oxygen, or a trach tube, or something that makes you skilled care. The bed has to be Medicare certified, but again, most nursing homes or skilled facilities do have a Medicare section. They got the beds ready to go. It's Medicare certified. They can provide that service for you. The problem is they changed the reimbursement process, the amount that nursing homes are reimbursed from Medicare with regard to these long-term care stays, to make it much more front-end loaded. Depending upon what kind of care you need, the facility gets a higher payment during those first 20 days from Medicare than they do later on. So the incentive is to get rid of patients where the reimbursement from Medicare has started to drop, so that they can bring in a new patient who's back to the full coverage amount in those first 20 days in order to get more money from a Medicare patient. So it can be hard to get. Oh, somebody just asked, am I advancing the slides? It's frozen on my screen. I have been advancing slowly. You might want to log out and log back in again. I don't know what's going on your computer, but I have moved them a little bit. We'll get it going a little faster in a minute too. In order to get the full 100 days of what you're supposed to get under the law, people have to fight it. You have to appeal. You have to say, look, I need this care. The law was changed by a class action lawsuit back in 2011. It was supposed to be all settled by 2016. That federal case that was a class action suit about getting the full 100 days, getting coverage in a facility, was called the Jimmo case, because the lead plaintiff, her name was Glenda Jimmo. And Glenda had been getting Medicare skilled physical therapy because she was in a wheelchair. She had diabetes. She had had a foot amputated, so she was getting wound care on that ankle. So she needed skilled care, and Medicare was paying for it. Suddenly they said to her, and a lot of other people in the country back in 2010 and 11, you're not getting better. If you aren't progressing, if you aren't improving, if you've plateaued, Medicare won't pay for it anymore because you have to be improving. And this Jimmo lawsuit challenged that in federal court, and actually the class won. The nursing homes, a lot of them claim they don't know anything about this lawsuit. I kind of believe that, because the Medicare and Medicaid agencies who were supposed to publicize this and follow the new rule that said you don't have to be improving. All you need is a doctor's recommendation that therapy or skilled care is medically necessary to maintain you or keep you from getting worse. You don't have to be improving. Most places ignore that, say you have to be improving and get you out of there as fast as possible so they can bring in these higher paid patients who are new to this coverage in the nursing home under Medicare. So don't just accept that the person isn't improving and the Medicare is going to stop. You have the right to appeal those decisions when you get a notification, and I would suggest you do, and argue that the Jim O case says that's not true. There is no improvement needed. It actually is allowable for the full 100 days if you are getting the therapy that's medically necessary to maintain or not get worse. So that's an important key thing. I tell a lot of my clients about that one. Okay, once you're done with Medicare, even if you get the whole 100 days and you have to stay in, Medicaid is really the main program that's going to cover that long-term nursing care. In most facilities, only about 40% of the people there are actually getting Medicaid. The rest are private pay or Medicare patients. So a lot of people don't understand how the rules work. Also, nursing homes don't want to have 100% of Medicaid patients. They don't get as much reimbursement from Medicaid per patient than they do from private pay patients. So they really want to have only a small percentage of Medicaid available in the nursing home. They, by law, if they're licensed to accept Medicaid, and I don't know of any nursing homes in the area right now that don't take Medicaid, they have to accept Medicaid. If the person qualifies, they have to take them. They can't kick them out because they went on Medicaid. They can't even kick them out if a Medicaid application is made. They have to accept that because that's part of the licensing. So they tend to try to say, oh, we have no Medicaid beds available, which isn't actually necessarily the truth. Every bed can be a Medicaid bed. They just choose to try to keep their percentages low for Medicaid. Now, the Medicaid program is the law that's a federal law. So the federal government sets everything in place and has like an overview law. Then each state is supposed to follow federal law. There are a couple versions of federal law that different states follow. Medicaid in Ohio went through a huge change in 2016 to change from one of these types to the other. And each state program follows the federal law a little bit differently. And even each county in each state follows the federal law a little bit differently. So you have to know what county you're processing a Medicaid application in. Cuyahoga County is big. They have a lot of people who need Medicaid. Therefore, it takes a lot longer, and they're a little bit pickier and sometimes difficult to get qualification through Cuyahoga County as opposed to some of the smaller rural counties around the state. So you really got to know who you're working with. Okay, so overview of the Medicaid program. First of all, you got to be a United States citizen or meet special rules. There are some people with green cards or visas who can get Medicaid, but as a general rule, you got to be a U.S. citizen, and part of what you have to prove to them is that you are. You have to have what they call a limiting physical factor. That means you need help. Usually what they're looking at there are activities of daily living. That means bathing, dressing, toileting, transferring, eating, those necessary things that people have to be able to do to take care of themselves in a day. If you can't do 2 or 3 of those activities of daily living, then you have a limiting physical factor and you're eligible on your health to qualify for the Medicaid program. If you're in the nursing home or you're trying to qualify for help at home, again, medically necessary. Almost anything under health insurance, you have to have a need that's medically necessary as determined by a doctor, so that can be covered by the Medicaid program. There are different Medicaid programs. There is the nursing home Medicaid that most people think of and is mostly where we're helping our clients qualify. That's the place where when you're in the nursing home, it's the most expensive. It's the first place that Medicaid was allowed. So it's the original place you had to be in order to qualify for Medicaid. Then they said, well, let's help people at home. It's a whole lot cheaper if we can keep them home than if we have to have them in the nursing home. So they came up with the at-home program, which is the Passport program. Now, each of the letters in Passport stand for one word of the title. I never remember what it is, and all you really need to know if you're asking for that is Passport. But then they went, wait a minute, there's some people who can't be at home but don't really need the nursing home, so they started a Medicaid program in assisted living facilities. That's called the AL waiver program. For both at home and for assisted living, the waiver part of it is that they're waiving the requirement that you have to be in a nursing home in order to qualify for Medicaid. There are a little bit different rules and regulations for at home, for assisted living, and for nursing home. But I'm going to focus on mostly assets and income eligibility, because that's the hardest thing. First, starting with a single person. So these are the income and asset rules in a nutshell for a single person. Under income eligibility, it used to be if your income was less than the nursing home cost, you could qualify for Medicaid. And I didn't have a whole lot of clients who had $8,000 or $10,000 a month in income. So it was not a big deal qualifying for Medicaid. Now they have an income rule. This is part of the change that happened in 2016. If your gross monthly income from Social Security or pension or PERS or SERS or any other income source that you have for retirement, if your gross income exceeds the income cap, which currently is $2,349, you're not eligible on your income. You have too much income. Now, there's a fix for it, but it's kind of a weird, complicated, makes no sense fix. What you have to do if your income exceeds that $2,349 is you have to set up a special irrevocable qualifying income trust, or QIT for short, which is what I have in the slides. So let's say your income is $3,349 and you're trying to qualify for Medicaid. Your income is $1,000 more than the income cap. So that means you or your power of attorney has to set up this special trust. And the special trust, you have to open it up and open up a checking account inside of it. And so your money comes into your regular checking, your bank checking account, just like you always had, and it's $3,349. You have to take $1,000 of your income and put it into the QIT checking account. That one step is magical, because now the income you have remaining in your regular checking account is $2,349, and you're magically at or below the income cap, and now you qualify for Medicaid. Now, that doesn't mean you get to keep the money that's in that QIT trust. When they're looking at your income, they take everything, add it all up. First, there's this determination if you need a QIT or not. Then, out of the total income you have, you are allowed to keep $50 a month for your personal needs allowance. That doesn't pay for much, and which is why, as we get into some of the planning, why it's important to try to protect some assets somewhere, somehow, because living off of $50 a month isn't really possible. They also allow you to keep out of your income your health insurance premiums or prescription premiums. There's a method by which, if you have some medical bills that haven't been paid yet, that your income ongoing can help pay for those. But whatever's left of your income after these little bit of deductions has to pay first to the nursing home as your patient liability, or what they now call patient share of cost. So you might have to pay out of $3,349, you might end up having to pay $2,050. So part of your money went into the QIT, so that money has to be used first to pay the nursing home. Then the remaining balance you have to pay after these few deductions comes from your regular checking, and you pay the nursing home with that. And next month, your income comes into your regular checking again, and you have to separate out that $1,000 into the QIT, and then you have to pay the nursing home out of the two accounts. And this happens month after month until you pass away or you go off of Medicaid. So the income rules weren't too complicated. Now they are very complicated. And you have to do it right. If you don't have a QIT set up when you go to apply for Medicaid, even if your assets are gone and everything else is in line, you won't qualify for Medicaid until that QIT is set up. And if it takes you 2 or 3 months after the application originally to get that set up and running, then you don't get Medicaid for those 2 or 3 months, and the nursing home won't be happy about that. So that has to start from the very beginning when you're applying. And most of the time, our clients don't even know about that if they're trying to do it on their own until they make the application and the caseworker looks at it 2 months later, tells them they need it, and they've lost out on the coverage. So it's really important. On the asset side of things, for a single person, assets include everything. So your bank accounts, your house, your cars, your everything that you own and could turn into cash, they want you to turn into cash and use it to pay the nursing home first. In order to be eligible, you can't have more than $2,000 in assets, which is usually less than $2,000 in a checking account where your income is coming into, and you'll be keeping that as you even go on Medicaid. There's a few exceptions to that. You're allowed to have one car if it's being used for your transportation. So somebody's driving you in and out of the nursing home or around with it, or you have a wheelchair van or something like that. Your cemetery plot is exempt. They let you have that little plot of ground to be buried in. You're allowed to keep an irrevocable funeral arrangement. It has to be irrevocable, because if it was revocable, you could go get that money and liquidate the funeral and use it to pay the nursing home. So it's irrevocable. Most funeral homes today know what to do. What you're actually doing is taking the money to the funeral home, you plan the whole thing out, you pay for the total amount, and then the funeral home takes that money and buys a single premium annuity with one of a number of different insurance companies that fund funerals like this. There's Forethought, and there's Golden Rule, and there's Homesteaders, and there's NGL, and there's even the Ohio Funeral Directors Fund. And what that purchase makes it irrevocable. Now, don't panic. If the nursing home you bought it through goes out of business, you actually, or the person who dies, is actually the owner of that annuity. And it can transfer then to another funeral home in case the one had gone out of business. And you're also allowed to keep your personal items. You can keep your stuff. They never come and take your stuff because your stuff isn't worth very much. Okay, now married couples. It's a little bit more complicated when you get to a married couple because it's a married couple. There's 2 people involved. And we've got one typically in the nursing home and one trying to live at home and make it on very reduced assets and sometimes reduced income. So let's go through the rules for income eligibility and asset eligibility for a married couple. So first, income. It's the same thing. Income, it used to be if your income is less than the nursing home cost, you could qualify for Medicaid. And it has changed now. And if you're married, it's the same as being single. If your gross income of the person in the nursing home trying to get Medicaid is over $2,349, then we have to have that qualifying income trust, just like for a single person. But they add a little something new into the rules when you're married because there's 2 parties involved. It could be the husband's income, it could be the wife's income. So when they're looking at the income of the person trying to qualify for Medicaid, they use the name on the check rule. So if this check is payable to the husband and the husband's the one trying to qualify for Medicaid, then it's his check when we're figuring out income eligibility for him. If it's the wife's name on the check and she's the one at home, then that doesn't come into the calculations for income at all. Out of the income for the married spouse in the nursing home, again, they get to keep their $50 a month personal needs allowance, health insurance premium amounts, past due medical expenses, and also something called the MMMNA. It's the minimum maintenance needs allowance for a married person. So the wife at home, a lot of times my clients, the wife at home never worked in many cases in this generation that's going through this now, and has a very small Social Security check based on half of the amount that her husband is getting. So if he's the one going into the nursing home, and normally all of his excess income, aside from those few things we talked about for a single person, would go to the nursing home, she needs some help too. If her income is below a certain poverty line, when considering mortgage payments or rental payments and homeowners insurance and some of the other costs like utility bills and stuff, if her income is too low, part or even all of the husband's income can be allocated to her to let her live at home. So it's a lot more complicated on the income side for a married couple. Now on the asset side, it's also more complicated. So here again, we've got two people. So what they do to determine how much each one gets to keep and have the one in the nursing home qualify for Medicaid, they add up everything. They pool all of the assets as of what's called the snapshot date. That is the first date in a hospital or nursing home that one of them had that was the beginning of a continuous 30-day stay. So for example, they went to the hospital and because of some bad thing happening, a stroke, a broken hip, a fall, whatever it was, they were there for 3 midnights, right? 3 days in the hospital, and then they transferred to the nursing home, and now they're in the nursing home for 27 more days. 3 days plus 27 days is a 30-day stay. So the snapshot date under those circumstances would be the first day of the time, the 30 days that happened in the hospital. So you got to figure out what that snapshot first date is. Of that, the spouse at home gets to keep the house, which we're going to talk about in a different slide because there's special rules with regard to the house. They get to keep a house. They get to keep one car, just like a single person, but it's got to be in the name of the one at home. Then everything else, aside from the house and the car, is all added up. Those are the countable assets. They're the assets that could be liquidated, turned into cash, and used to pay the nursing home. So the one in the nursing home gets to keep $2,000, just like the single person, and the one who is in the community at home gets to keep half of the countable assets, but not less than $25,728, and not more than $128,640. So what does that mean? So let's say we've got a couple and their countable assets are $100,000. They get to keep, or the wife at home gets to keep half of the 100, which is 50. The 50,000 falls between those two numbers, therefore that's all she can keep, and they have to plan with or spend the other 50,000. If that couple has 600,000 in countable assets, half would be 300, but that's way too much. The federal government says that spouse at home, that wife, only gets to keep about 128,000, and they have to spend down or plan with more than half. If, on the other hand, all they had was $30,000 in countable assets, half would be 15,000, but the minimum that the government lets that spouse at home keep is the 25,000. So they have to spend down quite a bit less than half of the assets in order to obtain Medicaid eligibility. Now, they're splitting assets between husband and wife, and the one in the nursing home only gets to keep a little bit, just like a single person. And the one at home gets to keep a house, a car, half of the money. They both get to keep cemetery plots, irrevocable funeral contracts, and their personal items, just like the single rules. So you'd think that there'd be a big deal about being separate assets, like if this was a second or third marriage and that couple did a prenuptial or anti-nuptial agreement and said, his is his and hers is hers, and we're not responsible for the other. Medicaid simply ignores prenuptial agreements. So it doesn't matter if you have a prenuptial agreement, you still have to spend down money, which is seemingly unfair, but that's how they do it. sometimes we've had to get couples get divorced and have those rules instituted in the divorce so that at least the wealthier spouse who would be able under the divorce with the prenuptial terms keep more doesn't have to spend a lot of that because of Medicaid eligibility for the less the spouse with less money. So, and as I said, houses and IRAs and other retirement are now special assets. So I'm going to talk about houses and IRAs separately. So when's the house exempt? A house is allowed to be kept in a revocable trust now. In the bad old days, not all that many years ago, if a couple had a house in a revocable trust, which a lot of people did for probate avoidance, it was this big thing to have this trust. Medicaid said, well, you don't own it in your name, you own it in a trust, and therefore it's a countable asset. Even though that would mean having to get rid of a house when a wife who is the spouse at home she has no place to live then if the house has to be gotten rid of. Thankfully, that went away. So now, whether the house is in the individual's names or in a revocable trust, it can be kept if somebody needs to continue to live there, like the spouse at home in a married couple. So as long as that one spouse is there, it's exempt. Now, what about a single person? We've had sometimes single people who spent all their money trying to stay at home, but end up having to go to the nursing home anyway when their money runs out. So what Medicaid rules used to say is that happens, your house is just exempt for 13 months. We won't make you sell it. We won't do anything with it for 13 months. Now that 13-month allowance is gone. What they say now is, we'll exempt the house, even if it should be countable because you're not living in it, if you file this paperwork with Medicaid as a part of the applications that say, I intend to return home. So that way you're asking Medicaid to let you have the house as an exempt asset in case you get better and you get to go home, at least you have a home to go to. The house can remain exempt your entire lifetime while you're getting Medicaid, and they won't make you sell it or disqualify you from Medicaid, because they know at the end, if you still own that house when you die after having gotten Medicaid, and Medicaid's run up this big bill of payments they've made for you, particularly if you're in the nursing home, there's this really cool rule called Medicaid estate recovery that says Medicaid has the right when you die to come after any assets you still have that they let you keep while you were alive. Single could be $2,000, it could be a car, it could be a house because they kept it exempt because they intended to return home. The Medicaid estate recovery rules say we can take now all of those assets to repay the state of Ohio for these fantastic Medicaid benefits that we paid on your behalf. We'll get the house anyway. So they're not too worried about it. If you have you're single and you're using this rule to try to exempt the house, it's really better to try to plan to do something with that house before you die so that we can get some of that money potentially out and protected, rather than Medicaid being able to force the house to be sold and take all the money and the family get nothing. There's also some exceptions for the house of how we can protect it. The house can be given to a caregiver child. So the rule for that is if a child moves in with a parent and provides care in that home for the parent that keeps them out of the nursing home when they should have been in the nursing home for at least 2 years, then Medicaid will allow the house to be given to that caregiver child, kind of as a thank you for keeping the parent off of Medicaid for some period of time. And because if the child moved in, that's their house. They have no other place to go. But it's got to be 2 years or more. If you're a day short of 2 years, that exception won't work. A house can also be given to a disabled child, either outright, if it won't interfere with the child's benefits, or in a trust for them, if it might. Disabled children can be given the house in trust. Also, there's a rule, let's say a house was inherited by 2 sisters when their parents died, and they've always lived together in the house. Neither one got married, and they stayed together in this house, and one of them has to go to the nursing home. As long as the other one had an equity interest in the house, like they owned half of it and had been living there for at least a year, together, then when the one sibling goes to the nursing home and tries to get Medicaid, the other sibling can have the house transferred 100% to them and still keep their home that they've been living in for some long period of time. So the house is an asset we plan very specifically for, and every case is a little bit different. We try to exempt it, we try to get it protected, and there's various ways to do that, but it just depends upon the situation. So one of the things that we have to do when the first spouse goes into the nursing home, the house has to be transferred out of joint names to the name of the spouse at home. And that's really important. We don't want joint ownership. We don't want it to be transferred on death back to the one in the nursing home. We want the one at home to own that house, because when the one at home dies, we want to title it so that it goes to their children or their other beneficiaries. If the house is joint and the husband maybe is the one in the nursing home and the house is joint in survivorship, if the wife at home dies, the husband will automatically inherit that house, and that can blow his Medicaid. Or if he tries to then claim, I intend to return home, they may reject it because he's been in a nursing home already for 4 or 5 years when the spouse at home died and left him the house. So we don't want that happening. Also, if the one in the nursing home dies owning a half interest in the house, it'll go to the spouse at home initially. But Medicaid keeps a little eye on that half that the one in the nursing home owned while getting Medicaid. And when the wife dies, they're going to want to come after that half interest that she inherited from her husband, who was at the time of his death in a nursing home getting Medicaid. So we have to do some titling changes. The healthy spouse has to disinherit the ill spouse in their will, just in case anything goes through probate. We don't want it going back to the spouse who's in the nursing home and blowing the Medicaid. If the healthy spouse dies first and everything is supposed to be going to the kids, we don't actually want anything to go through probate to pass under the will to the kids, because if anything goes through probate of the healthy spouse who died, that gives the ill spouse in the nursing home extra rights to say, wait a minute, I don't agree with everything going to those kids. I want to take a percentage back as the surviving spouse. And there is a law in the probate rules that say that spouse can do that. So if the law says the spouse can do that, Medicaid will say, well, okay, if the spouse doesn't take that money that they're entitled to under law, we're going to pretend that they took it, gave it away to those kids who are getting it, and then they're ineligible because they made a gift of those assets. But if they do take the money that they're entitled to under those election rights in the law, then they have too many assets and they're disqualified from Medicaid anyway. So we have to be careful. We try not to have a probate at the time that the healthy spouse, in case they die first, and we have nothing going back to the spouse in the nursing home by disinheriting them and naming children or others as the beneficiaries on those assets. So, and this all goes back to these Medicaid estate recovery laws too. We don't want anything there that Medicaid can come and grab even at the death of the second spouse. All right, now IRAs. This is really brand new. This is just happening this year. The old rules for IRAs said that an IRA or other retirement account is an asset. It's a pot of money that you can access. And if it's a pot of money you can access and you have to be down to $2,000 of assets if you're single, that means you have to liquidate and spend and pay taxes on that IRA, spend it or plan with it to get rid of it so you don't have that asset as a part of your $2,000. That was actually pretty straightforward. Now they're changing the rules to say something entirely different. So most of you know that when you hit a certain age, you have to start taking required minimum distributions, like from IRAs and other retirement accounts. It used to be 70 and a half, but this law changed it to now age 72. So nowadays, if you're trying to qualify for Medicaid and you're over 70 and a half under the old law, or over age 72 after January 1st of this year, you are in payout status. You have to be taking these required minimum distributions. So if you're taking required minimum distributions, now that's an income stream to you, and the underlying IRA pot of money is not an asset. So they're not counting the IRA at all like they used to, but the income is part of what is coming to you, could make you over the income cap to need a qualifying income trust, and is going to be going to the nursing home to help pay that bill before Medicaid pays their percentage. So that sounds really nice. The IRA doesn't count against you. The income's going, well, the income would have gone anyway. The problem with this new change in the law, remember how if the house was exempt because you intended to return home, that at your death they could take the house? Here it's the same idea. At your death, that pot of IRA money that's left is now an available asset, and it's subject to Medicaid estate recovery. So they get it while you're alive monthly, and then they take the rest of it at your death because they paid out these Medicaid benefits to you. So this is not a good thing necessarily. It's just another tweak in the law that we have to look at in deciding what's the best way to deal with an IRA. Do we want that outcome, or do we want to just liquidate it and spend it down like the old days? The other issue is if you're not yet 70 and a half or 72, and you're not in payout status getting required minimum distributions, then this rule doesn't apply, and that asset, the pot of money, becomes an asset to you. Under those circumstances, there's a certain type of an annuity that you can get to change that IRA into an income stream. Will have no more asset left because you took the whole thing and you're having it come out to you monthly over your life expectancy under Medicaid's table. Now that just means it's going to the nursing home each month. However, remember for a married couple, we talked about name on the check rule. So let's say it's the husband getting Medicaid and he's got the big IRAs. If he can annuitize those IRAs to get rid of the asset, and with certain annuities and with certain companies that you buy them from, that husband says, I'm going to do an irrevocable assignment of this income stream to my wife. So pay those checks to my wife. Don't pay them to me. Then when Medicaid looks at the income coming in, it's not his income because the check is payable to her. The income doesn't go to the nursing home every month because it's not coming to the Medicaid applicant or recipient, it's going to the spouse, and she can keep that money and rebuild the money again once she gets all those checks back. So IRAs have become much more complicated these days. Some of the ways, a big way that we use to protect assets is to gift assets. Even though the rules are harsh, you can still gift some assets even at the last minute. So one way is you plan ahead. You got 5 good years left. You say, I'm going to just give away all my money now to my children or to an irrevocable trust of some sort. And as long as you don't apply for Medicaid until 5 years goes by, that they won't see that gift in the 5 years prior to the application, and it'll be free and clear. But if you can't make it a full 5 years, or you're not real excited about giving your kids your money because you want to keep control of that money until you absolutely have to give it away, then there is a crisis type plan that we use. So the gifting rules say that if you make a gift of assets within the 5-year look back period, then Medicaid, when you're applying for Medicaid, they want to see all of your bank records and investment records. They want to see, did you give away any money? If you gave away any money within the 5 years prior to the application, they punish you by creating a penalty period. So the penalty period is a number of months that Medicaid won't pay, starting from the month you would have been eligible, And going forward, because you made a gift during the 5 years prior to that month of application. How they figure out how many months of ineligibility there are, they take the value of what you gifted divided by the average cost for 1 month in the nursing home in the state of Ohio, which is, as I mentioned earlier, $6,905. It's not what you're actually paying the nursing home, which could be much higher. They just have to have a standard number. It's the average of all the nursing homes in the state. So if you made a $50,000 gift and you apply for Medicaid within 5 years of that gift, they will see it because they want to see everything, and you're required to tell them under penalty of perjury. And they'll see, oh, well, wait a minute, your money was gone, but you made a $50,000 gift. We don't like that. We're going to penalize you for that. So we're going to take $50,000 divided by $6,905, which is about 7 months. That's how many months they think you could have paid for the nursing home with that $50,000 if you hadn't given it away. And then starting from the month you applied for the next 7 months, there is no eligibility. They won't pay because you're in this penalty period. So it starts when you apply. It doesn't start when you give away the money or anything. So even at crisis time, we can do some gifting planning. So if we're at the last minute, which is oftentimes the case, people don't plan ahead. People like to just let things go. If we have a single or a married couple and somebody has to go to the nursing home, first of all, there's typically excess assets. You want to spend those assets on yourself or on your health care or on your spouse first. You can pay for the nursing home, pay for the assisted living, pay for in-home health. You can buy things that they will exempt as assets, like your cemetery plot or an irrevocable funeral agreement. If you have enough time, you can gift and wait 5 years, but more often than not, it's a wait-and-see crisis plan. So first of all, we're going to look at the IRAs. What do we do with these? Are we going to exempt it up front and just let the income count because you're over 70 and a half or 72? Are we going to annuitize it? Are we simply going to liquidate it and spend down the money? So we have to look at the IRA pot of money very carefully. If there are disabled children and assets can be given to them, either the house or assets can be given to them either outright or through a trust, that's a possibility. Last resort, if there's still assets left over after all of these other options we're looking at, we do a special plan where we're trying to protect some of the money. Usually even at the last minute we can protect about half of the money, because we need to have, if we're going to gift, we know there's going to be a penalty period that they're going to start, and we have to be able to pay that penalty period. So if you give away all the money, the penalty period will be really long, and you'd end up spending all the money paying for the penalty period. So it usually works out to be something like half and half. We can protect half by spending the other half to pay for the penalty period. So let's take that example. I said $50,000. And that would be a gift that would cause about a 7-month penalty period if Medicaid saw it. So, if a single person has $100,000, they give away $50,000 to their children or an irrevocable trust. It's very personal how we decide what to do, because we want that money protected for the person who gave it away for the rest of their life. So they give away $50,000. We know it's going to cause a 7-month penalty period. So they got to use the other $50,000 to pay for that 7 months. The problem is, if they had $100,000 and only gave away $50,000 and they still have $50,000, they're way over the $2,000 they're allowed to have for Medicaid eligibility. So Medicaid won't even start the penalty period, which means we have to get rid of the second $50,000 also, in such a way that it's still available to pay during the penalty period, but is not an asset of the person applying anymore. So he had $100,000, he gave away $50,000, that's the penalty period of 7 months. What's left to us after many different variations on a theme for Medicaid purposes is to take the other $50,000 and buy this special annuity that changes the 50,000 asset into an income stream coming back to that person every month during the 7 months. So a little bit comes back every month of the 7 months. That money that comes in the annuity payment is combined with the income of that person, and we have calculated how much can be gifted and how much has to be annuitized so that it's just enough to pay the nursing home privately during that 7-month penalty period. So we can do planning even at the last minute. It's very personal, very fact specific. The Medicaid rules change a lot, and oftentimes even without warning to us who are paying attention, they just change them overnight seemingly. So there's planning tools. Unfortunately, most of this crisis plan and some of the gifting plans to disabled children and others, you need help doing. Medicaid is really a welfare type program. It should be easy for people to be able to simply qualify, but what the qualification rules that Medicaid tell you is spend it all and then we'll help you. And spending it all till all you have left is $2,000 in the bank and $50 a month is not helpful for most people being able to have any kind of meaningful life the rest of their life, just because they end up having to be in the nursing home. So, there's planning things that can be done. So how do I protect my family? Ask about this information. Thanks to you who are attending, because you're taking that step to learn about how Medicaid works. The Department of Job and Family Services in the county is the one who handles the Medicaid applications. But they're going to tell you what they want you to hear because they don't want to pay benefits. They're trying to keep it away. The nursing homes will tell you what they want to have you hear because they want to have private pay as long as possible because they make more money that way. And hopefully you all understand, you can't trust everything you find on the internet. Our website is great and you can look there, we got good information, but that's not always true everywhere. Medicaid, even though should be a do-it-yourself kind of a process, isn't. You got to understand the rules. It's best to start planning early. We do a lot of Medicaid planning and have for many years. The folks who were willing to plan that 5 years ahead and put away the money into an irrevocable trust or even to their children and waited 5 years, it turned out typically to be the best thing that, the best option under the circumstances. Because if the look-back period is currently 5 years, it used to be a year and then a year and a half and 2 years and 3 years, and now it's 5 years. It's easy for the government to make it 7 years or 8 years or 10 years. And if you've already given away assets under the 5-year rules, that's grandfathered in. It always has been in the past, but past performance doesn't guarantee future returns, as they tell you on your financial stuff. That doesn't mean it's necessarily going to be so, but that's historically how they've always done it. So doing it when it's a 5-year rule rather than waiting until it's 8 or 9 or 10 years is easier and better. You can protect more assets. So you need to get professional elder law help. I'm a certified elder law attorney. That means I had to take this test, a day-long test, to prove I knew all about estate planning and Medicaid eligibility and Medicare and some VA and some special needs planning and a whole lot of things. As you age, your needs change. You don't just need to have estate planning documents. You need more help with other issues like nursing homes and long-term care, and how do you get into the assisted living facility that you want to be in, and how does that payment work, and so many other things. So it's not just setting up your documents, it's also all of these other changing rules that happen as you age. Now, don't get me wrong, you still need estate planning. So you got to have a will, you got to have a financial power of attorney, you have to have a healthcare power of attorney, you need a living will if you don't wish your body to be kept alive when you're gone and there's nothing that they can do. And in some cases, you need a trust agreement. In some cases, you don't. It just depends upon your particular circumstances. So I guess the bottom line of you having listened to here, you know that there's a lot of stuff with Medicaid. There's a lot of rules, laws, there's a lot of planning you can do, there's a lot of rules as to how that planning must be. take the step to find out for you what that means and do what you are comfortable with planning as far ahead of time as you possibly can. Last minute, yes, there's a few things we can do, but it's certainly not as easy as it could be if you planned ahead. I had one lady, she came in hoping to do some asset protection for her husband who had just recently entered the nursing home. And I asked if she had his power of attorney, and she said, "Oh, yes, I do." And she showed it to me, and it was written when he shipped off to World War II. Now, in those days, powers of attorney were no good if you became mentally incapacitated. And this poor guy was mentally incapacitated. So I had to tell her that that power of attorney that they thought they were fine having from World War II times was no longer valid. There was nothing we could do to help her. So there are things that might need to be updated. Even if you have these documents I mentioned, the rules change and the terms of those documents may have to be updated. It's always a good idea. We recommend our clients every 3 to 5 years take a look at their documents, maybe even have us take a look at their documents to make sure they reflect the current law and the provisions that you're going to need to undertake some Medicaid asset protection planning. If your power of attorney won't let you, it makes it very difficult to do anything at the last minute. So, we thank you for being in attendance on our webinar this afternoon. Nobody else asked any questions apparently, so either that's a good thing or a bad thing. I told you everything you needed to know, or you weren't paying attention. So hopefully you were paying attention, and we thank you for attending. Look at our website. We still have some more webinars that the firm is sponsoring coming up in the month of October. So take a look at that, and if there's anything else you're interested in, please come back. Oh, I got a question. Yay. Have you resumed in-house consultations? Yeah, this pandemic has changed a lot for everybody this year. We do have some in-house, and you were paying attention, you're overwhelmed. Yeah, I get that. I hear that a lot from my clients. I try to give as much information as I can for people, and it is a lot. So we encourage you to come in and make an appointment. And do we have in-house consultations? Yes, in some cases we do. Our attorneys and our staff are working, some in the office, some at home. If anybody goes out of town, they got to stay at home for 2 weeks, just like everybody else does. So we're trying to be really safe, and we do have some in-house, but we also use Zoom, like this webinar was presented in Zoom, to have more face-to-face appointments, but keeping everybody safe, and sometimes telephone consultations. It just depends on what people need. So thanks for paying attention. We'll be following up in the next few days, next week, to send you a copy of the slides and a copy of the outline that we would have handed out if we were in person, like we used to do our seminars in person. And if we can help you in any way, please call the office, make an appointment. We usually say we need about 2 hours for an appointment, because we talk about the family, the assets you have, the documents that you have, like wills and trusts and things like that. And we talk about what planning, what are you trying to accomplish, and try to come up with a plan that's going to accomplish what you want. So it usually takes about 2 hours. So we do charge for that, but during this pandemic, we're charging $275 for that entire meeting, and even a follow-up meeting if we haven't quite finished, because people need this information more than ever now. Now, the Department of Job and Family Services are still working at home. Most of their case managers are at home, and I got to tell you, in Cuyahoga County, because they're not in the office drinking coffee all day long and talking to each other, we're getting applications actually through faster now than they were before the pandemic. So I guess there's some silver lining on that, having them work at home. But anyway, I'm over my time. I don't want to keep you too much longer, because I want you to have a good Saturday afternoon, and I thank you so much for coming, and we'll just end this thing now. Give us a call if we can help you. Thanks. Bye-bye.